Greetings, friends of the channel. Welcome to my YouTube. And today I wanted to share with you a call I got yesterday from a friend of mine. He says, "Hey, bruh, do you see that tomorrow is the day for your former premier, the Secretary General of the ANC, to appear in court? How would you approach this situation? And or how would you advise him as an accused person in terms of dealing with this case?" So immediately, I didn't want to get involved, and I really don't like to get involved in political issues. But what prompted me to make this video is an opportunity that I saw to advise fellow South Africans about how they should approach their own situations if they would be facing criminal charges or disciplinary cases, even in the workplace. These are general principles. They say nothing about whether there is a case against the SG or not, and I do not want to get involved in the political tussles. But as a lawyer, I think there are certain things that are important that all of us can really take note of, and all of us can certainly benefit from. So what is the important things? The first thing is that we must understand what we are dealing with. So immediately when you are dealing with a legal battle, you must understand that it is just that. It is a legal battle, and every legal battle requires then legal tools to be able to sort out. Now, it is not time to be emotional. Remember, at this stage, there's a prima facie case, so on the face of it, there is certainly something to answer. It does not mean that you are guilty. It is part and parcel of a democratic process of accountability. So when there is an allegation, it is not the end of the story. When our forefathers drafted the constitution of our country and drafted the laws of this country, they had these accountability issues in mind, and this is but one of the ways in which we account in a democratic setting. One of the other important things that I want to highlight is that whenever you are in a situation like this and you realize that you are the only one being seemingly pursued, but you have knowledge of other people who have done similar wrongdoing, you must not get worked up, and raising that is not going to help you deal with your case in terms of its merits and demerits. But certainly, if you have knowledge of wrongdoing or criminal activities that were conducted by any other person, certainly as a citizen, you have in fact a responsibility to go and report to the appropriate authorities, being the SAPS, the Hawks, or anywhere else where you would want to where you can report. However, you must understand that these external issues have nothing to do with the strength or the weakness of your case. And making a noise about it is not going to make your own case go away. So what I will then suggest is that you focus completely on the case that you have to answer. And that is basically the essence of it. And what is that? It is the offense that you are dealing with. It is the elements of the offense that you have to deal with. Because it is only through that process that you would be able to deal with the center of gravity of the state's case and then be able to be victorious ultimately. The important thing also is that whenever you are in a serious case, or especially where your life, especially where your career, and more importantly, where the future of your children might be compromised, you have to first take it seriously. You have to take it seriously. It is not a walk in the park, and you cannot afford to be laxy-daisy about the process. What do I mean? The first thing is that you must lawyer up. You must lawyer up. Now, I will never, ever advise any South African, especially when they are confronted with a serious case, to represent themselves. It is dangerous. Judges, advocates, attorneys, most experienced people in the profession, when confronted with similar issues, they get another counsel, another attorney to represent them in a court of law. This is very important because immediately when you are personally involved in a legal matter, the emotions are very high. And because the emotions are very high, objectivity goes out of the window. Ability to reason and to think clearly and logically becomes very diminished, and it would compromise, in my personal view, your case. Now, when you lawyer up, remember, when you lawyer up, one, you have to dig deep in your pockets. You have to dig deep in your pockets because there'll be attorneys involved, depending on the level at which ultimately the case will go. Advocates will be involved, and that is a very expensive exercise. It is even more expensive exercise if it would be a protracted case. The good news, though, is that within our South African legal system, we have a right in our constitution and our law to legal expense, legal representation at state expense. So you can certainly exercise this right. Also, another thing that you must keep in mind, whenever you are involved in a serious issue of this nature, you must, in my view, exercise the right to remain silent. Exercise at all material times your right to remain silent. That does not mean you are a coward. That does not mean you are stupid. It does not mean you cannot fight. It means that you are waiting for the right platform, the right time to be able to bring your issues at the relevant platform. Now, it is also important at this stage, this is another thing now, you must at all material times be very clear, especially when you go in to deal with an attorney, about your instructions to that attorney. What you want that attorney to do, how you want that attorney, or issues that you want that attorney to raise. It's important also, it's another thing, when you are dealing with a serious case, that you must brief the right person for the job. So you must certainly look at competence, you must certainly look at experience, and you must look at also the area of law that is in question. Because then you would require, in my view, a specialist in that area or field of law. Now, first, allow me then to deal with the do's. What should you do as an accused person? One, you must show up. Because to the extent that you refuse to cooperate, one, you'll get yourself in trouble because you will end up behind bars a couple of times with the prosecutor and the police trying to enforce your presence in court. And that is an unnecessary process. Not cooperating can only delay, but doesn't stop the issues that must be addressed. Secondly, when you are with the attorney, it is important that you be honest to the attorney. It is essential that you be truthful to that attorney. And the first thing that you must discuss is the cost. The cost, how much will it cost for you to defend me in this particular case? Just like the case in question that I introduced in the beginning, the SG will have to dig deep in its pocket and will have to consult with his attorneys and get a rough estimate of how much this would cost from the beginning of the process and ultimately to the end. The other thing that's important is you must know that the attorney was not there when these issues took place. So you must start at this point to gather all your documents, all the information that is necessary for you to argue a case, and you must give those promptly to your attorney. The evidence, you must bring them to the attorney. And it's very important that there be clear communication between you as an accused person and the attorney that will be presenting you. When I mean also communication, I mean that you must certainly be of one mind in terms of what's going to happen and be at the same place in understanding the issues. You don't want to be caught up with unnecessary negativity and animosity between you and the attorney because there is miscommunication. So clear communication is what is recommended. Again, whenever you have arranged a meeting with your counsel, it is important that you always be on time. Don't be late, because remember, he is setting time apart from you. He is not in meeting with other clients, and that costs money. Because time is money, do not be late for your appointments with your attorney. There is this other issue that's very important that I must emphasize at this stage, and that is you must be willing to take your attorney into confidence, or whoever is representing you. And you must be willing to follow meaningfully their legal advice. Because remember, you might know more about the facts and what happened, but they know more about the law and the application of the law and how to conduct your case. The other issue, pay your bills on time. Pay your bills on time. This I must re-emphasize, because if you don't pay the bills, the attorney will simply take your file, put it on the shelf until there is money for him to do his work. It's also important that you realize the seriousness of your case. It is very, very important. Understand the seriousness of the case, understand what is at stake, and understand the potential impact that your case might have on you as a person, on your family, and those around you. You cannot sit there and think that the lawyer will do everything for you. He'll probably do a lot. But it is also incumbent upon you to educate yourself about your case. Read up a little bit about your case. What is this offense that I'm being accused of? What are the elements of this offense? You understand? Read previous cases that deal with similar issues. You are a party to this proceeding, so at least take it serious and inform yourself. One of the other important things is get to understand what are your rights at all material stages, from the time the investigation starts through the court proceedings and after. What are your rights as a citizen, as an accused person? The Constitution provides clear guidance on these rights and many other documents. Again, understand what winning means. People often think that winning is about not guilty when it comes to conviction. Certainly that is part of it. But sometimes winning is about getting a reasonable sentence, or a more lenient sentence than you would normally get for a similar offense. Why is that important? Because when you are in the process of conducting your case, how you present yourself, how you deal with the prosecutor, with the judge, might create an impression about certain things. I'll get to this shortly. The other thing that is important is understand the case against you. Understand the case against you. Another thing that's important is when you are, especially either in consultation or in court, when you are being asked questions, listen attentively. Don't start to develop answers before the person has concluded his question. And once the question is concluded, take a moment, think about it. And once you have a clear understanding of the question, provide only that answer that is necessary for the question that is asked. This is whether it is your own counsel that maybe is asking a question, maybe in cross-examination, the other party or the judge. Answer, listen and answer clearly. It's also important, not just clearly, but calmly. The fact that you get angry, the fact that you get agitated maybe, or that you are unhappy with the type of question that is posed, or that you make a noise does not elevate the level of your argument. So be calm, be clear, be logical, be succinct when you are dealing with your issues. This is very important. Why? Remember I said I'll get back to it. Why is this important? It's important because, one, you are creating an impression in your behavior, your attitude, and your conduct in court. And this, the judge might decide that, no, there's no remorse with this person. In other words, this person is arrogant, he has not learned a lesson, and cannot be a good candidate for rehabilitation. Maybe I need to provide a more serious sentence. So always stay calm, stay relaxed, and understand that the presiding judges are human. And how you treat them might have a negative impact on you. Again, it's important. Never ever panic. Never panic. Don't be scared. Remember, the judges know that you have, for example, a benefit of presumption of innocence. They know that you can be, either guilty or not guilty. So they are never laboring under the impression that you are guilty. They already believe that you are not guilty until proven otherwise in a court of law. Again, the burden of proving a case against you is not on you, it's on the state. They must prove their case beyond reasonable doubt. And that is a very, very high standard of proof. So, do not assist them in dealing with their case. They must prove it. That is a very important thing. However, there is a situation where you can go and decide that you're going to plead guilty to whatever offense that you are charged with, and that is also okay. But before making that final determination, make sure that you consult clearly with your attorney that is representing you, understand the implications of what you wanting to do, and the consequences that might flow, especially from that particular plea. And it is very important. So those are just a number of do's that you must do as a person, and it is very critical. Then lastly, let's deal with the issues of don'ts. What are the don'ts? The first don't is don't talk to the police. Don't talk to the prosecution and the criminal investigators about the merits of the case. Exercise your right to remain silent. That is the first thing. From the time you are charged, zip your lips. Again, don't try to contact the victims or the witnesses and try to interfere with the investigation or them. It is undesirable and will only create more problems for you than is necessary. Again, don't try to panic, go destroying and burning papers and evidence, hiding things. Don't do that. It is not necessary, because in the end, it could certainly hurt you. Again, there's this thing. We live in an age of technology, social media, and all these nice things. However, never, ever, 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 ever post on social media issues that relate to your case, especially the merits of your case. Never, ever address media houses and organizations about your case, the merits of your case, especially once it is there is a case against you. And if really there is something that you feel as an accused person that you want this to be addressed in a public domain, allow your attorney to do it on your behalf. Don't you do it for yourself. Because when you are addressing and a journalist is asking you questions, you might just disclose things that might be detrimental to you in a long term. And that is not right. What are the other don'ts? I've emphasized this, don't disrespect the presiding officers in the court, prosecutors, and witnesses. Be very courteous at all material times. And don't be sidetracked by issues that are not material to the case or unrelated to the case, because they won't assist you to win or lose the case. So it's important that you focus on the case, because the case is what's important. Again, never lie to your attorney. Never, ever, ever lie to your attorney. Or tell your attorney, have truths, because he must stand up in court and argue your case on your behalf. He must go to court and say, Judge, it is my instruction that A, B, C, and D has happened, and it has happened in this way. So if you're giving him snapshots, he's going to be surprised in court when the other party bring information that you are aware of that might compromise the case, and he was not prepared for that. So always be truthful as far as you can with your attorney. Anyway, there is a client attorney privilege, so you are safe when you tell your issues to your attorney. In conclusion, these things that I've shared with you are just principles. They are general. And it's not a close list. It's not a close list of all things that must be considered. And that is what you must keep in mind. I will later also, remember now I'm focusing on what an accused person should do or should not do, or how he should go about assisting himself or assisting his attorney so that he can be represented effectively. Now, having said that, I will make another video where now I look maybe as to what the attorney should do, considerations that the attorney must have in mind, looking at the strategy in dealing with the case or the tactical plan that is necessary to then meaningfully prepare for your case. And lastly, I wish every single South African that is involved in a criminal case, disciplinary case, or any other case or situation where he has to answer for himself, success. And ultimately, it is about the best interest of justice. It's about the best interest of justice, and justice will certainly prevail. Just give yourself a better chance to fight your case. Don't make unnecessary or stupid mistakes. It is very important. Handle yourself professionally, carry yourself in a respectful manner, and understand every step of the way is very important to the end state that you want to achieve in your case. And even if you maybe are not fortunate enough to win in your case, at least you have created a good enough impression for those that are presiding over your case to give you a benefit of a doubt or a second chance to live your life. Having said that, the winner at the end of the day, in my view, in all of these things, must be the citizens of our country, the people of this great nation. They must be the winner, because justice is meted out on their behalf. The debt that is being owed is owed it's owed to society, the citizens of this great nation. So ultimately, when justice prevails, they are the winners. So thank you very much for listening, and definitely look forward to my next YouTube video, and I will try my utmost best to ensure that it is vibrant, it is powerful, and that it's something that is worth listening to. Thank you.